Hello, everyone, and thanks so much to Megan and LAC for hosting us today. I'm Harriet Fischer, staff attorney at the California Women's Law Center. I'm super happy to be here with you all and with my esteemed colleague, Arati. The California Women's Law Center works to create a more just and equitable society by breaking down barriers and advancing the potential of women and girls. We do this by litigation, policy advocacy, and education, focusing on gender equity issues such as economic security, violence against women, women's health, and gender discrimination. As you probably know, domestic violence disproportionately affects women in every area of their lives. So we hope today's presentation provides some helpful tools for you to use in advocating for DV survivors. And with that, I will hand it back over to Arati. Are you going to share your screen?
Okay, sorry, I needed to open this up again. I lost my little window where it had gone down. So let me share my screen. Aha. Okay. Let me put it on slideshow. I feel like I'm forever figuring this out for the first time, as if I haven't done it a bunch of times already. So hi, everyone. My name is Arati. I'm a senior managing attorney at Family Violence Appellate Project. I'm so happy to be here with my colleague Harriet Fischer at the California Women's Law Center. We collaborate on so many amicus briefs and other things, and so we've been able to support each other a lot over the years, and they're a great partner for us. And happy to be here through LAC, and thank you, Megan, for the opportunity. I always love these trainings. So I'm trying to figure out if I could just see some of the video. I usually like to see at least one person, and it gives me the opportunity to have, oh, here we go. Perfect. Okay, excellent. All right. So just briefly about Family Violence Appellate Project. Also, just to clarify, you are going to get a copy of the slides. And we'll be happy to take questions, not only at the end, but if you have questions after the presentation is over. So we are a California and Washington nonprofit. We primarily work on representing clients at the appellate court for free. We do it in partnership with pro bonos. We also do amicus briefs, and we provide a lot of technical assistance. So as part of that work, one of the things that became very clear from the moment FVAP was founded was that one of the barriers, and there are many, but one of the many barriers to getting effective appellate review was insufficiencies, deficiencies, problems with the record. We get a lot of referrals. And there is nothing more frustrating than knowing that had something procedurally been done a little bit different, or had something been included, or had something been, in a transcript or something like that, that would have made all the difference. Because most of us who've worked with survivors or work in family law, we know what's really happening, right? But for the appellate court, if it's not there in black and white somewhere, whether it's in the transcript or something else, it's like it didn't happen. And so you're stuck at that point. So even though you can read between the lines, or what was going on, or the context, or what happened the day before, if it's not in the record, it's not going to help you on appeal. So that's why, even though I think we've probably talked about this in multiple spaces over multiple years, and maybe this is your not your first rodeo with this training even, I think it's important to keep doing it. As we take more and more complex cases, the need for having a good record is increasing. As you can imagine, where the rules become tighter and the discretion of judges gets tighter, the means in which they try to get around that, if they really don't want to do that, is more sophisticated, and that requires a more sophisticated record on our part for supporting our clients. Okay, so having done that pitch for why you should have given up your lunch to be here, let's talk about what is a record. All right, so what is a record and where is it used? It is not that dusty looking thing that was there in the previous slide. It's all documents in the court file and any available transcripts from proceedings where a court reporter is present. Now you may think, oh, record, that's only necessary for appeal, but really it isn't. It's more than that, right? Because what you have in your case file, which is a record, is going to be used for the duration of the case. It could be used for a new case, also post-hearing motions, and then of course for written appeal. So it doesn't have to be just a situation where you're going to be doing something on appeal. And just to get back to this too, I think the other piece of it too is that you want to think about, especially when we're talking about the duration of a case, one of the things that I see happen quite a bit in reviewing cases is that sometimes someone will not include a declaration or an exhibit from another hearing in the papers that they submit to the court for that particular hearing. So for example, let's say there was a restraining order and it was settled and they agreed to some type of non-klutz order. And then 2 years later, they come back and they're filing another restraining order. Attaching the declaration from that order 2 years ago is incredibly helpful. And not having an expectation that even if it's the same judge, that it's going to be read is helpful. Like, so that when you're talking about all the documents in the court file, it's not just it's in the court file somewhere. It's also really important to consider what documents are in front of that judge for that particular hearing, for that particular request, even if it's somewhere else in the case file. Okay, so what makes an ideal record? All the necessary court appearances have a court reporter, and I wish that that was something that we had more control over, and unfortunately we do not. I think we are all much better about knowing that clients are entitled to a court reporter when they have a fee waiver, but there's still so many loopholes. You know, we saw last year, LA almost stopped court reporters for a period of time until there was a lot of negotiation. So this tends to really be a problem. What this means, though, is that you need to have a lot in writing. And it's unfortunate because that really disadvantages people who are self-represented. But the more that you can have in writing, whether it's your points and authorities, your declarations, your witness declarations, that type of thing, the more things that you can have in writing, the better you are able to do something afterwards, even if you don't have a transcript. Trying to appeal something without a transcript is pretty impossible. There are some options for that. I think we've done it once, but it is incredibly painful and very, very difficult. So even if you don't have a court reporter, you're pretty likely not to be able to appeal. But it still would be helpful in terms of having the documents that have the information that you need, even if it's for the next hearing. It's also important for things like a post-trial motion, because in some cases, well, actually in a lot of cases, even if you have a court reporter, you're not going to get the transcript in time. You know, one of the frustrating things I think that all of us who've practiced have experienced is this idea that somehow, you know, the other side is asked to write up the order for the court, and then they're supposed to send it to you, and you're supposed to review the language and agree. But if you disagree, you need some proof, and you usually want the transcript. And aside from the fact that they're prohibitively expensive and most people cannot get them, it's next to impossible to get, especially family law, because they don't expedite them the same way that they do for criminal, or they don't take priority over criminal or juvenile ones, to get it in time to meet the deadlines for you to be able to support what you're saying about what the record actually said. Yes, the court can do it, but still you really want to be able to have the transcript yourself just so that you can see, because, you know, our memories are imperfect, everything goes really fast, and it's just better to have the exact language. The court has ruled on all objections. So what does that mean? Sometimes you'll get a situation where a judge will say, I'm going to rule on that later. I want to hear some testimony and then I'll figure that out. And somehow in the process of everything, no one remembers that they never said anything. It's not bad lawyering per se. It's just the fact that we're all human and there's so many things going on. So you really want to have some way of tracking, right? And the other piece that's difficult, I'll talk about this, you know, it's not like we have 3 people to come in with us for court, right? A lot of us, especially if we're doing legal services, it's just us. And we actually need about 6 hands instead of 2. But if there's any way that you have to keep track of your objections that you made, some people, what they do is they have like an exhibit list, and then they have a column for where they objected, or they have pre-prepared the objections they have for the other sides, and that way they can kind of check it off. In some cases, you might have an idea about the kinds of things you're going to object to, not necessarily in a motion in limine, but the things that you might object to if it comes up in testimony. So you might have that written down, but as much as you can have pre-prepared so that you don't have to remember everything in your head, the better. The court has ruled on all motions in limine. This is another thing where, you know, maybe you want to get that video in, or the other side wants to get some video in, and you've written this beautiful motion in limine about why it shouldn't get in, and the court's like, I'm going to hold off on that, right? And then it's day 3 of your trial, which the 3rd day is happening, you know, 4 weeks after the first day, and nobody's talking about that video anymore, right? But you have to get something on there. You have to get the judge to say something about it, right? Even if it's pretty clear that the judge has already decided that they're not going to take that video, they have to rule on those motions for the purposes of the record, okay? The court states what it has reviewed in making its decision. You know, sometimes you'll see these things, I've reviewed all the declarations and the exhibits submitted. That doesn't mean they've read the whole court file. Sometimes they'll say, I've looked over the court file. That doesn't mean they've read every document, right? But you want to see if you can get them to say something about what they read, right? Especially if you're in a situation where maybe there's some supplementary declarations, maybe the other side was allowed to file something last minute and the court accepted it even though you objected. If you can get the court to say what it actually reviewed, that can be helpful, because when you are filing an appeal or doing some type of post-trial motion, you can say this information was in front of the court because it was in this document and the court said it reviewed it. So even if for some reason something didn't come up during the hearing, you know, either for time or just the flow of things, you can argue, and it's not that you can't argue it otherwise, but you absolutely can argue in these situations. If the court said it reviewed all the declarations and there's information in the declarations that powerfully supports your case or that supports your case, the court should be held responsible for that, for knowing that information. What it is not necessarily responsible for is the entire court file. And we'll talk about that a little bit more. The court has ruled on all the orders you've requested, including underlying and additional orders. One of the worst feelings in the world is realizing that you didn't preserve an issue for further review. This is especially true with restraining orders, right? It's not that you never have an opportunity again to bring that issue up, but the timing of that issue makes a difference, and you miss out on the advantages of timing if you either don't have a ruling or have not preserved that ruling. And this happens a lot with restraining orders, particularly. It happens in other situations as well. And honestly, it happens the most with support. And that's particularly difficult because support orders can be retroactive to the request. So yeah, it's a sickening feeling to know that you didn't preserve the timing on a child support request that happened because it was in the context of a DVRO, and they rushed you, and you were just so grateful to get the actual restraining order. You have to have somewhere in the record where it says that you asked for it, and even though the court didn't get to it, they are going to set another hearing. You've said that it's wrong that they not get to it. You've asked them to set another hearing, and they've refused something on there. Okay, court gives its findings of fact and what they are based on. The court states the law it's using, its conclusions of law, and the basis for those conclusions. The court has ruled on all the issues before it or set any remaining issues for a future hearing. That sort of relates to what I was just talking about. And then for the purposes of appeal, no review hearing is set, or it's clear that all that's left is enforcement. And that's where we're talking about finality of an order. And that's incredibly difficult in family law because so many of the orders we get for child custody and visitation, for example, are temporary. And temporary orders as a whole are not appealable. As far as the findings of fact and conclusions of law and things like that, I think there can be some misinformation about what all that really means, right? Findings of fact are, I found that this person did it, right? I found that this person was more credible than that person. I found that this incident did not happen. I found that, that type of thing. And then the conclusions of law that they're making are that this is not abuse under the DVPA, right? This is not, this is sufficient to represent the best interests of the child based on this law, right? But there are also findings that are sort of conclusions, and that's why it gets a little bit tricky, right? Because you talk about findings and then there's findings of fact. So again, a finding of fact is, this person did show up on that day when there was a no contact order, right? A different type of finding is, there's been no, there's been no further incidents of abuse, and person has shown that they are, committed to working in the best interests of the child, right? It's kind of not a fact to say that you believe someone's committed to working to the best interests of the child or has changed or reformed, but it can be used in that way if a judge decides that that's, so to some extent its opinions become findings of fact. Okay, what did I do here? Okay, submitted via motion memorandum all the relevant statutes and case law, and where appropriate, social science. Don't, don't be afraid of social science that support your client. And this goes back to, again, what I was talking about before, where you just never know what's going to happen at a hearing. You never know when you're going to be cut off. You never know when the court's going to say, you know what, I've heard all I need. You never know when the third day of your hearing where you plan to do this, that, and the other gets knocked off or gets put really far down the road. So you want to see as best as you can that you have things in writing so that the court can be held accountable for those things when you are on review, right? And this is one of the trickiest things because we all know there's so much stuff that happens that's off the record, right? And judges, I've been in courtrooms where they deliberately take things off the record, because they want to, be influential in some ways. And sometimes, judges call you into their chambers and they're like, you need to settle this, right? Or they'll make other statements that essentially either, or they think they're trying to be helpful and help you avoid litigation. Maybe they're trying to pressure you. Maybe they've, already come to a conclusion based on the papers. And so they're saying to you, look, do you really want to go through with this? But the fact of the matter is that if you want another court to understand that that had an impact, You have to get that on the record. And it doesn't mean that a judge is going to like it, right? Obviously, if they, you know, I've had situations before where, you know, or I've had attorneys tell me about situations before where they've asked to have a court reporter in judges' chambers and been denied. They've asked to have, you know, they've asked for the court to restate what it said in chambers on the record and been denied. That's not a fun position to be in, right? When it comes to trying to have a positive relationship in court. But one, any good judge wouldn't hold that against you because that's just part of being a zealous advocate. And two, you need to show that you did that to the appellate court. You need to show that. Okay. Again, ask the court to rule on each issue. Some of this is a little duplicative, I'm sorry. Ask the court to rule on each issue in your request and preserve it. Argue the issue of harm and prejudice to your client. This is one area which I didn't really quite understand, or maybe I didn't appreciate it as much until I got into appeals, right? For appeals, in most cases, it's not enough to say that the court did something wrong. You have to prove that but for that error, it's reasonably likely the client would have had a different outcome, right? So this comes up a lot in criminal cases, right? But this issue of harmless error. Now, in working with DV survivors, you sort of think, how can anything be harmless error? It's all harmful, right? If you know, they're seeking protection, their safety, it's the protection of their kids, they need finances. But you really do have to argue it. You really do have to argue it because for appellate courts, they can say, oh, well, yeah, that was a mistake, but the court was going to find this anyway, right? So you really have to explain why it's why it would be harmful either that the court rules this way or that the court has ruled this way, or argue that as part of your case, right? It's tricky because you don't have to, particularly when you're talking about a restraining order, you don't have to prove likelihood of future abuse. And even with a renewal, you don't have to prove reasonable apprehension of future abuse where the abuse is the same type, right? So it's a very tricky line that you're walking there where you really want the court to understand that this is going to be harmful for the person without saying, I'm telling you that this abuse is going to happen again, and I'm proving that, and you have to agree with me in order to give me the restraining order. And then, of course, in addition to admitting all relevant evidence, objecting to or keeping out all irrelevant or improper evidence, right? And that's where, you know, it's in some cases you need to speculate a lot, right? Like if it's a trial and if everybody's followed the instructions and you have an exhibit list and all that, you have some time maybe to prepare. But sometimes in these shorter hearings, for sure, you don't have that. You don't know what's going to be shown. One of, I think, the most difficult things of trying to preserve an ideal record is slowing things down when it needs to be slowed down, because ultimately the judges have control of the timing of their courtroom. And so sometimes at best, you can say, this was not sufficient time. We need to set another hearing to talk about this more. We were not able to get to this, and this, which are critical for actually making a decision, something like that on there. So at least you can talk about it in your appeal, right? Because again, if it's not somewhere you can point to after the fact, it didn't happen. Okay, we talked about objections, etc. Okay, we did that. All right, so let's talk about challenges. I've already talked about some, right? The timing, short hearings, continuances, short time frames, review hearings, multiple issues and motions at one hearing. I mean, I think we've all been there where it's 20 minutes and it's like an RFO to change custody and a DVRO. So the lack of predictability and the lack of clarity on how much time you're going to get is a huge factor in this. So again, that's why putting things in writing, for better or worse, is going to be your friend. it's a disadvantage to pro pers again, but it's going to be your friend, because if you don't get time, it's still in the record in front of the court for purposes of review.
Arati, can I
Yes,
stop real quickly?
please.
There was back to the issue of prejudice.
Uh-huh.
One of the attendees asked, just to clarify, are you suggesting arguing the issue of harm or prejudice in your closing, or do you have to have alternative suggestions on how to do this?
No, largely it's your closing, right? But again, the problem is that you don't always get a closing, right? Depending on who you're with. Sometimes you get a written closing, sometimes you get no closing. So you have to figure out a way, if you can, and it could be just in the declaration, right? Or it could be in your memorandum of points and authorities, and you talk about how in all these other situations, the court found it was prejudicial, and this situation is the same, right? And yeah, in your closing, but somewhere it needs to be in there, right? Like one of the things that I always talk about when I'm talking to people about restraining orders is that you have to actually argue each of the points that you're asking for. There's so many check boxes in restraining orders. There's so many check boxes in our family law documents, right? And sometimes it's easy to think that because we checked it off, we asked for it and that's all we need to do. But you really actually have to argue each one of those. You have to argue why you think a batterer's intervention class is important. You have to argue why you think, whatever additional order is that you've asked for. It's not enough necessarily to, I mean, I'm not saying that you have to do things like argue why it should be 100 yards stay away from the car versus work versus the home. Usually with the stay away, that's a little bit more all or nothing or pretty close to just whatever you check off. But in most cases, you do have to argue what you've checked off. And this is no different, right? Giving an idea of the harm or the fact that it could come out differently if the court didn't do this or didn't admit this evidence or something like that, is something that you want to do. And it can maybe, change the result. Anything else?
I'm just going to interject super briefly.
Uh-huh.
Just so you know, we're about 2 minutes away from 12:30. Wow.
Okay. All right. I will keep going and we'll just go from here. So deference, right? I think we've all, it's a constant battle. Especially if you practice primarily in one county, right? These are judges you're going to be in front of day after day after day, right? These are judges that you're going to have to be in front of on the same case for different issues. And there's always this push-pull between, am I hurting my client by being aggressive? Am I, ensuring that even if I get this thing for the client later on down the road, it's going to be held against them? That kind of thing. It's a constant push-pull. And I think, to suggest otherwise is to be unrealistic or naive. You will get pushed back on if you try to object to every single thing, or if you try to, point out every little mistake or anything like that, right? You will eventually, with most judges, some judges can look back on that and say, like, you're a very detailed attorney, you're very diligent, all this stuff. They can even say, you know what, I didn't like it, but I know you had to do your job. As long as you're not being obnoxious about it. But it is, it slows things down. I can't remember who this was, so I apologize to this attorney who told me this story. I think she was in something and she had been objecting to something that was repeatedly coming up, and the judge basically said to her, you can either keep objecting or we can go home today. Right? Like, what are you supposed to say to that? No, we're not going to go home today because I have to, right? So sometimes you try to do things like a running objection. This is where motion in limines can be helpful too, because you have sort of a standing thing that you've already shown that no matter when it comes up in the case, you've already objected to it. But yeah, you can't just pretend as if you know, you can do whatever you want. Judges like to control their courtroom, and it's, you know, it's sometimes a judgment call. The important thing, of course, is that, you know, your client knows what's going on and what you're doing, and that your client knows what adjustments you may have to make. It's in fact easier if you know for sure that this judge is not going to agree to what you want to, right? Because then you don't have any barriers necessarily to making sure everything gets on the record. It's more tricky when it could, you know, when it's more either or you just don't know, or it feels like it's so much more related to the type of person your client is. Multiple judges. Oh my gosh. How many different ways can this be a problem? Okay, so of course, judges change over time, right? If you've worked on a family law case before, or you've talked to as a survivor before, they'll tell you, oh, I finally got a judge who gets it, or this judge got it and then they left, and now I have this new judge and I have to start all over again. And it's really hard. It's very hard for the clients, but it's hard for you too, because you have to figure out, where are we starting here? You're not starting from scratch, but this judge is essentially starting from scratch, right? Did they read everything that happened over time? Did they just read the motions that were filed for this? Did they skim the court file? That's where you have to kind of ask some questions, right? Or you have to make sure that something that you had before that you really want this judge to know is refiled again, right? Sometimes it can just be judicial notice. Other times you can, you know, file it as an exhibit to a declaration. But getting that in front of that particular judge for that particular order is important. Obviously, you have these situations where you have one judge for your DVRO and one judge for your divorce and one judge for your child support, right? You may have a small number of judges, and on any given day, you have a different judge because they do everything. You can show up and there'll be a pro tem or a commissioner there. And frankly, there isn't a clear, bright line rule or clear accountability for having read the entire case file. And when you think about it, how realistic is that, right? You've been working on this case for 4 years, and a new judge comes in and they're going to read every declaration and every ex parte and every mediation report, et cetera, right? I think it's actually helpful, I think, to a judge to help guide them to what you think are the most important documents in the case file for them to review, right? And I know some people talk about, should I re-summarize everything? Should I keep saying the same thing over and over again? And this can sometimes help a little bit with that as well, because it is, you know, you have your 10 pages of a declaration. You don't want to irritate a judge who's already heard the case once before by repeating everything, but you need to make sure you get information in on that day for that order. Okay, court reporters and types of hearings. Half the time they, you know, we get in these situations, I've heard it over and over again. People think they are showing up for one thing and it turns into something else. You think you're showing up for a scheduling conference and the TRO ends up getting modified to order visitation. You think you're going to a status hearing and something else happens. And because of the type of hearing, there's no court reporter there, right? So those are also things that you want to object to and figure out a way to get in writing, right? Even if it's like a declaration, you have to file with the court to say, you know, we just had this hearing, this happened, you know, it should have been reported, or I asked to stop it so that it could be reported, that type of thing. And again, doesn't make you, you know, the most popular attorney in the family court system, but it's what you need to do, because there are just too many things that happen that are, you know, there's just too many ways in which procedure is manipulated to disadvantage folks. And it's terrible. And most people are not in a position to do anything about it because they're not represented. And then, of course, taking the short and long view. I mean, I think when I started doing, before I started doing appeals, I was basically like, why do I care when No one I represent can do an appeal anyway. They don't have the time, they don't have the money, they don't have the luxury of waiting that long. And you know, if something really is wrong, I'll figure out a way to get back into court and do it again. You know, even if we have to wait a couple months, I'll just figure out a way. And that's not wrong, but you don't have to do one at the expense of the other, right? I think we've thought before that if we can do whatever we need to do in that hearing to get the order, that's enough. And it doesn't really matter after that as long as we got the order. But I think, you know, most people who do this work understand now that it's all a process. And the documents you file in one hearing on one issue are documents that you can file in another hearing on another issue. I had a case where it just turned out that in the request for child support, the person had put in issues about domestic violence. And it was in front of a judge who later denied that person a restraining order. And because of that, I was able, even though the child support was not an issue, I was able to take that document about child support that mentioned domestic violence and put it in front of the appellate court and say, here, look, she's been talking about domestic violence since, you know, 4 or 5 months before she even filed for a restraining order. And this judge knew it, right? Okay, so what does an ideal record do to you? It proves to the trial court or the reviewing court that something did or did not happen because it's in the transcript, admitted into evidence, or part of the record. Understandably, though, an ideal record may look differently depending on whether you are challenging an order or the order is being challenged, right? If an order is being challenged, you know, you want to make sure you've closed all the loopholes. If you want to challenge an order, you want to make sure that, you know, you've got the court committed on certain things, even though you know it's going to be error, right? So that's always a little bit tricky too. But eventually, I think the way I feel like it comes out in the wash is that what you need to do for both still ends up being the same. And it's just dependent on the judge that you have, right? In a best case scenario, you do all of this and it leads to a better outcome for your client. You have a stronger chance at a post-trial motion. You have a stronger chance at the next hearing. After that, if that's not how it's going to work, you have writs and appeals and you have a stronger case for a written or an appeal, right? But either way, your options are open. You know, there are no options that are closed off because that wasn't the mindset for that wasn't there. Again, what if I'm not challenging the order? A thorough record is essential. Cases go on for years. Prior facts, evidence, hearings will come into play, right? You cannot count on the fact that the judge who's hearing your case now about visitation modification is going to have watched the video from 2 years ago where the other person was screaming in front of the kids, right? Even if it's in the court file, you have to bring it back, or you have to have a transcript that talks about it and then attach that section of the transcript. And again, cases have different judges over time. This is especially important when you're talking about a renewal case for a DVRO. This is where we see this a lot, right? Even though it's known that the underlying facts that support a restraining order renewal can be enough to issue the renewal, and the other side is not supposed to relitigate the renewal, you still want to be very clear about what was the underlying evidence for that restraining order, right? And that can be the declaration that was filed, the original DV-100, all of those things. You want that to be a part of your record on a renewal, right? Even if the documents themselves don't ask for it, even if it's a different judge, it's 5 years ago, you bring that DV-100 or whatever it is that you need to make sure that even though you're not relitigating the supporting facts, you're making it clear how strong the supporting facts are and why that's enough of a basis for your client to have reasonable apprehension of future abuse. All right. I want to also take this moment to show that I am somewhat of a family law nerd, but more importantly, there are lots of things in the family code that you can count on to hold systems accountable, right? It's not perfect, it's not everything, it's not in all the sections that you want, but it's there, and they keep increasing, right? One of the things that we know is that when courts have to make findings, when they have to go through factors, it helps interrupt bias. It helps make them spend more time on something. It makes them more careful, right? So if you look in the family code, there are plenty of places where courts are required to make findings or a finding, where they have to find good cause, where the word must is used, right? And what do we know about that? Shall and must are the same. Shall appears in this many sections in the family code. Yes, I do have a social life. But shall is mandatory. It's not permissive, right? And shall not is prohibitory, right? So sometimes what happens in those situations is you get a word like solely, which kind of undercuts it. So for example, one of the questions I get all the time is the issue about courts making decisions based on the length of time since the last incident of abuse, or courts making decisions about the length of time from the last incident of abuse and when they filed, even if it's a shorter time period and things like that. And yes, the family code says very clearly that a court cannot deny a restraining order based, so it says shall not deny or must not deny a restraining order based solely on the date of the last incident of abuse. So that solely kind of undercuts it there, because it's difficult to prove that that was the only reason and there wasn't some other reason, right? And that's why if you think that's what your judge is doing, it's important to get more things on the record. Okay, so yes, you want to use the statute's language to make sure you get the findings and language you need to support your request. Even if the order is not what you want, the findings in there are going to be important, right? So you can have a case where a judge made a finding that was in your client's favor and the ultimate order is not what your client wanted. And that actually could be error, or that could be abuse of discretion, right? We have case law that says that you can't deny somebody a restraining order and then tell them, you know what, you better be careful, you better behave, this person can come back and get a restraining order, right? You're essentially saying you found that there was abuse, or you found that there was a reason for them to be afraid, but you're not giving them the restraining order. So that finding or those other things are still important. It's also important for, renewals, for future hearings, and it could be important for a later order that you want to challenge, even if it's not the order that you have. As a caveat to this, I get questions sometimes, and there's been discussion about using statutory language in declarations. And that's happened a lot, particularly with the discussions around coercive control, because again, in spite of the fact that we have the language, a lot of courts are not getting it. They're not recognizing it. They're not seeing it. They're not wanting to. And so it's sort of like putting it in their face a bit.
We're at 12:45.
Okay, thank you.
Mhm.
Personally, I don't like the idea of putting statutory language in a declaration. I mean, if you look at a declaration, it's supposed to be personal knowledge. It needs to be something that your client can talk about on the stand and sound the same, right? It needs to sound like them, and it needs to be something that they can repeat. You don't want these situations where, a client gets cross-examined and they're like, oh, I didn't know I said that. My lawyer wrote that. Or, they stumble over something in the declaration because it's not how they would normally speak. So putting in statutes and even statutory language, that's not how most people speak. And it's not something that someone is going to be able to repeat on the stand. So I tend to shy away from that. I think if you can add a boilerplate P&A, a couple of pages, something like that, you can maybe put it in the form, in the request, you can describe abuse and then maybe, put the statute in the margins or talk about it at the end. But in the declaration itself, where the client is testifying from their own personal knowledge, I don't think putting statutory language in there is really what that's meant for. Okay, I'm going to spend a little bit of time on this, and then we'll spend about 10 minutes, maybe answering questions. So we'll just do like a couple more minutes. So this is basically, you know, I think moving it to admit exhibits into evidence is sort of a basic thing. It's just, you know, you can never you can never be too careful on these things. It is so easy to go through periods of time and you got the evidence approved, you overcame the objections, but you never actually moved it into evidence, right? If some of you are familiar with this Featherstone case that came out last year, right? The person who was in pro per had a deed showing that she had a community property interest in the property. She asked the other side questions about it. The judge knew about it, but she never moved it as an exhibit into evidence. And so the court justified making a decision as if she had never put it in, right? That's extreme, and thankfully that got overturned. But you don't ever want to be in that position. And certainly a lawyer is not going to get forgiven for that. Again, declarations. I think we're in a good place right now where pretty much the declarations attached to a restraining order get included without being separately admitted, right? It's considered part of the request. It doesn't mean that the other side cannot object to some of the things that are said in it, but as a whole, you don't have to separately admit the declaration of a restraining order, you know, the declaration to a request for a restraining order as a separate document. Supplemental declarations, probably, right? And it really just depends on your judge and the other party, right? Some other parties will go line by line and say, I object to number 12, this particular phrase. Other parties don't do anything about it, right? Or they save it for cross. And in some cases, you do get judges who just on their own, you know, will say, well, you know, I didn't keep reading any of that stuff because to me that seemed like hearsay, right? So you want to be careful. It makes it difficult with a restraining order because sometimes you're under a time pressure to get it out. And so you put the bare minimum of what you think you need, and then you file a supplemental declaration. That's obviously better than nothing. And at the same time, you can also be punished if you take too long on a restraining order for having it take, you know, be so long after the last incident of abuse. So you're really put in a difficult and an uncomfortable and sometimes a no-win situation. But again, the cleaner you can keep your declarations, the less that they're about, you know, character assassinations or, you know, that they're personal knowledge or state of mind or, you know, party opponent statements, that kind of thing, the easier it will be for you to get those in. Right. And then this is just sort of the thing about testimony, right? Again, they have to make a finding of good cause to refuse it. Nobody says exactly what good cause is, right? And that's always tricky, but they still have to make that finding, right? And then this is just some stuff about admitting declarations for domestic violence. And then this is about sort of, again, establishing prejudice. And then statements of decision. We talk about statements of decision a lot. Feels like a broken record a little bit, or a dusty record, as was shown. But you know, we keep getting new cases about statements of decision. Just last year, there were 2 new cases about statements of decision: City and County of San Francisco v. HH and Abdelkader v. Akbar, I think. And both of them were about, you know, statements of decision, ironically, in 3044 cases where there's already a requirement that the court go through the factors and put them on the record. So it's a good idea to reread the rules sometime, you know, every time, you know, anytime you have like a free moment that you might want to otherwise sleep or interact with other human beings. It's a good idea, though, to reread these, to reread the front of the family code sometimes. That can also be helpful because there are tools within the family code we can use to help us, or at least get documented for the purposes of the Court of Appeal that make it more difficult for people to work around them. Okay. Sorry, I appreciate that that was a little bit rushed, but we only have an hour and this can normally be like a 2.5 hour training, especially if I'm allowed to talk nonstop. So questions?
Regarding putting a declaration or other evidence from a prior hearing or proceeding in front of the court in a subsequent proceeding, which you talked about closer to the beginning.
Yes.
We have a question that asks, can we incorporate that prior declaration by reference for appellate purposes or attach it as an exhibit?
Yes. Yes, that's an easy way to do it. You know, that, so yes, you can do judicial notice, but you can absolutely attach a prior declaration as an exhibit to an existing declaration. Not because it means that it's not going to get noticed if it's judicial notice, but it's just pushing, it just makes it more likely it's going to get read, hopefully, you know, considering the amount of time they have. You know, judicial notice means they have to take the document or you have to give it to them separately. Maybe that's a way of bringing it to their attention more. I don't know. But, and you know, do both if you want to. The more the merrier, especially if it's really something important that kind of helps detail a lot of things that you don't think you're going to have time to go over or get in front of that judge for that particular thing.
Okay, thank you. And next we have a request for any guidance on how we balance when to push the court to make clearer orders and being more specific with its orders, and balancing that with the reality that court calendars are full and we're getting limited time for our hearings or having to possibly face getting moved to long cause or getting
Yeah. Well, I mean, to some extent, that's where statement of decision requests come in, especially when it's a custody or visitation hearing, where courts are supposed to honor those requests in particular. Because what you really want to do is, if you're not going to have enough time, the primary reason you ask for a statement of decision is so that the appellate court will not infer that the court did the right thing, right? You want the court to look at everything anew, if it can. So part of what, even if the court doesn't give your statement of decision, even if, you know, just by virtue of the fact that you asked for it, you submitted something asking for those things, you're going to get some protection. The other thing that's important about findings is that courts cannot make up findings, like appellate courts cannot make up findings that a court may have made if the court's clear about its reasons, right? So even if it's possible for the, you know, the court to have made a different outcome under different reasons, if the court says the reason I denied this restraining order is because the last incident of abuse was 6 months ago, and so I don't think a restraining order is necessary, you can't say that the court actually denied it for other reasons. The court denied it for that reason. And so that's why it's important to try to get some of those things on the record. Again, I think the more complicated the cases get, the more important it is that we push, because we're not doing our clients any favors either way, right? I don't know. I mean, it's obviously a personal decision, and you know the relationships with the judges, but you know, I think one of my favorite compliments, or a compliment, not as if I've had many, but a favorite compliment I've had from the judge is, you know, I always appreciated having you in my courtroom, Ms. Vasan. I was pretty sure that every time I opened my mouth, you disagreed with everything that I said, but you always did it respectfully. So there you go. Right? Like, there's going to be some judges who, you know, they know. And if they're really, you know, judges should respect that. They should respect you for advocating for your client. And they should respect your legal acumen in trying to keep your record clean. And you can always say, just for the record, or to preserve the record for my client. Sometimes that's a way to get out of it.
Okay, thank you. Do you have any advice on what to do if a judge refuses a request for a statement of decision that is timely made?
Call us. Call us. those are kinds of cases we take, right? You can, there's some information about post-trial motions, and I'm along with the slides, there's some handouts about that. So you could try to have it handled in a post-trial motion, but absolutely this happens. I mean, the case that I talked about last year, which was City and County of San Francisco v. HH, statement of decision was requested and the person didn't do it. The judge didn't do it, and that was held to be prejudicial. Of course, we had to go through the appellate process to get that, which, you know, in some ways feels like, you know, maybe a Pyrrhic victory. But yes, it's those are issues that can be done on appeal.
Next question is, if there are no objections to the declaration and exhibits attached to a DV 100 request, are all objections waived?
Pretty much, yeah. 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 I say pretty much because I have seen situations before where appellate courts have independently ruled that evidence was not admissible, which is unfortunate. And so there is always that possibility. And as I said, you know, sometimes judges will say, well, you know, I disregarded this because to me, this was hearsay or something like that. But in terms of the other side not objecting, and then the court doesn't do anything about it, for sure, yeah.
I have one comment and with a question. It says the courts are always trying to make us take back our exhibits. Is there a respectful way to ask them to keep those, or should we just keep taking them back?
Oh yeah, this is another thing too. And especially if you want to do an appeal, right? Because it's like you need all of those things. I think the court rules right now are allowing them to do this because there are so many problems with storage and scanning and things like that. So I don't know that there's a way for you to get them to keep them. Are you talking about, if you're talking about before the court makes its decision, there may be more of a pushback on that. You know, sometimes you have trial and then the court doesn't issue an order until 3 months later. And you're like, why do I have the exhibits when you're supposed to be looking at them to make your order? So that I could see. But in general, the taking back of exhibits is probably just going to be here. And there's really no way to, because they don't have any place to keep them and they don't want to have to organize them. And these cases get bigger and bigger and bigger. You know, there are some places that have the, you know, pilot programs or the ability to scan things, and that's one thing, but not every court does. So you kind of just have to keep bringing them back. And that's also why a transcript is important, because the transcript is supposed to list all of the exhibits that were admitted, and it's also an opportunity, even if at the end or the beginning there's okay, let's go through all the exhibits, you can get that on the record that they were all admitted. You know, all plaintiffs' exhibits A through E were admitted and F was excluded. Even if that's on the transcript, that's helpful.
Okay, one more just came in. It says some judges get really mad when we ask them to put the chambers conference on the record. Why are they so defensive about this?
Oh my God. Well, if somebody wants me to pay to get my degree in psychiatry, I'm happy to answer that. I think at this point, we don't have a choice, right? There are just too many things happening. You know, I have had reports of judges who push people to make non-klutz orders on DVROs. They push them to take the kids off. They, you know, these kinds of things. And sometimes it happens with pro pers, sometimes it happens with one person represented, and it's not right. It's not right. And, you know, maybe if more judges are held to account for doing that, then you know, they'll stop, or they'll realize that. I mean, there are definitely judges who, I don't want to make like a blanket statement about all judges, but they're definitely you know, judges who are doing it because they really do believe they're being helpful, and they're trying to get things worked out, and they're trying to avoid, days of litigation or contentiousness. But especially in domestic violence cases, there's so many where it's just about getting somebody to give up their rights or give up their position in a way that's not often favorable to a domestic violence survivor. The other thing, I didn't point this out, but frankly, one of the things that came up in this case last year, this city and county of San Francisco, is that the judge kept putting up their hand to get the attorney to stop, right? And that's not in the record, but it happened. And I told this attorney, if that ever happens to you again, you put that in the record. You put that in the record. I don't care how mad a judge makes you, it makes mad. Your Honor, I see you're putting up your hand to get me to stop talking. Is there a reason for that? Or Your Honor, I see you put up your hand to stop me from talking, so I'm going to stop talking right now, whatever it is, because those things don't show up on a transcript, right? We talk about that with witnesses a lot of times, if the witness does something, or you make sure you get it in the transcript. You need to do that for judges too, sadly.
Well, it doesn't look like we have any more questions, and we're at just about 1:02. So if there are no other questions.
Great.
Yes, we're
Please
done.
fill out the evaluation if you can. That'd be great. Okay, so I'm just looking, and all these questions are from people who are incredibly smart and do this all the time and probably knew all these answers. So hopefully there's some people out there for whom this was new, and for that you can get something out of it because it's the first time. Again, the slides will be sent, and happy to answer questions afterwards. If you want to email, reach out. We do technical assistance. So if you have a case specific question or anything like that, happy to answer, and look forward to hearing from all of you and getting all of your referrals from all these judges with these beautifully laid out records. So have a great rest of the day.
Thank you for joining us for today's webinar. This webinar was hosted by the Legal Aid Association of California, also known as LAC. We are the membership organization for California's civil legal aid nonprofits. Our job is to advocate in the legislature, in the courts, and with the State Bar of California on behalf of the community of nonprofits that serve low-income Californians. In addition to our online and in-person trainings, LAC provides coordination and advocacy for increased funding to support organizations like yours. Thank you.